Hi everybody, welcome back to Crafting and Crime Daily. I am Rebecca, I am your host, and I recap live trials, so you have something to listen to while you're working on your crafts. Crochet, cross stitch. I'm doing a diamond painting right now. You want to see? Hold on. I'm in the middle of putting the black outlines in, all the black. But it's almost done, actually. Almost. Dun, 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 dun. Look, I added the little bats down here. So I am actually working on all the black that's in here. I'm just filling it all in. And then I will go back and fill it in with the rest of the oranges and the yellows. And I've been playing around with the different size drills, the bars, the cubes. If you want to see those drills and add them to your painting, go down to in the description. There's a link to diamondpaintingdrills.com. I'm an affiliate there. If you go to that site, peruse all the beautiful stuff she's got. She's got these gorgeous glitz diamonds that I've put around the edge. I don't know if you can see how they have that beautiful shimmer to them. It's almost like a glitter. Yeah. So I've put that all around the edge. I put it up in the stem. In any case, she's got those in all different colors. So check it out. If you happen to make a purchase, I do get a small commission. But how cool is that? And I do want to put something up here in this negative space. Maybe another bat or two, or I don't know. I haven't decided yet. Still thinking about it. Yeah. All right. How do I want to go about this now? Okay. Trying to think the best way to finish this up. Okay, this way looks good. All right. So because I'm only covering one case, I feel like I don't have much to talk about. I'm so used to covering so many cases at the same time. There is another trial that's starting today, but I am. Oh, how did all this get? Oh dear. I got stuff everywhere. Good Lord. I am not covering the other trial that just started today. It's a trial where this woman is being charged with murder for putting Visine eye drops into water, and her significant other. Honestly, I haven't even looked at who's who, but I just want to tell you what she did because it's so weird. She put Visine eye drops in the water, and the woman drank it and died. Ooh, yeah. Anyway, I'm not covering that one. It's just too much. Because once we get into the Charles Adelson and we got Kowalski to finish up with, it's just too much. I don't want to confuse you guys by talking about so much stuff. So if you're working on a craft and you would like to join my Facebook group, Crafting Journey, you can put a picture of your work in progress there so I can see what you've been working on while you're listening to this channel. All right, so we're going to talk about Maya Kowalski. The defense is putting on their case in chief, and they've done a pretty darn good job so far up until yesterday. Oh my God. Yesterday, I think the defense attorney needed a change of underwear. Yeah. So I'm going to show you there's what happened in the courtroom because it's very subtle. You don't kind of you gotta kind of know what's going on to know what's going on, because otherwise you wouldn't know what's going on. And you're like, what is she talking about? Okay. So within the last few weeks, and it's not widely reported, but there has been some talk about Maya Kowalski having a, a recall of a sexual assault while she was in the hospital. And the plaintiff wanted to amend their complaint to add a count for this sexual assault. And the judge was like, no, it's too late. Too late. And it's not going to be mentioned in this courtroom. No, we're not going to mention it. And what happened is a doctor walked in, allegedly. This is all allegedly. This is what she recalls. A doctor came in. Well, you'll see it in the video. He describes what she recalls. But it basically pulled the drawstring on her pants, asked to look at her private area, didn't touch her, looked at her private area, and then proceeded to leave the room and said thank you. But it made Maya, who was 10 years old at the time, very, very uncomfortable. Now, the person that is on the stand is this neuropsychologist. She is a doctor, PhD doctor, not medical doctor. She does not go to medical school. However, she is still a mandatory reporter. So she is doing behavioral psychology. What do they call it? Cognitive behavioral therapy for Maya while she is in the hospital. While she was a prisoner at John Hopkins Hospital, she's being treated by this woman. And what this woman does is she comes in and she says it doesn't matter whether Maya's pain is, Munchausen's by proxy or CRPS or, conversion, whatever it is, Maya is perceiving that she is in pain. So that's what I'm going to treat. Her thought, her brain is telling her she is in pain. So she's working with her on how to basically trick her brain into thinking other things, how to tell her brain to go somewhere else when that pain comes. And, she's teaching her to write her thoughts and keep a journal. And anyway, that's cognitive behavioral therapy. Well, one of the visits, and the defense calls her as a witness, and they're going through each and every visit that she has with Maya and what she does during the visit. Now, there's one particular visit that they don't touch. They do not touch this visit. And so the defense attorney, he goes through all the different visits, what she does, or she showed up to do a visit and dad was there and she couldn't do the visit because she wanted to let Maya have her supervised visit with her dad. And so the defense attorney asks her, before I turn this over to, plaintiff counsel for questioning, I have one more question for you. He says, did Maya ever complain to you about any mistreatment at the hospital? Dun, dun, dun. The drama started. Because her answer was no. No. Well, they go sidebar. Toot sweet. They go sidebar. And finally, they come out of the sidebar, and the judge tells the jury, listen, this is going to require more than just a few minutes. I'm going to have to send you guys for a break while we work this out. So what he did was he had the plaintiff attorney proffer what questions he would ask this witness based on the question that the defense attorney just asked, including the note that they did not show to the jury. This note said, all right, here, I'm just going to play this clip for you. And it's about 10 minutes long. Watch this clip.
Mr. Anderson or Mr. Whitney, did Maya ever complain to you while in the hospital about any negative interactions with Kathy B?
No.
In fact, did Maya ever complain to you about any concerns she had with mistreatment in the hospital?
No.
Did,
please. Court reporter, this is going to be designated as a proffer. Doctor, there's going to be some questions that are asked. We may or may not ask these questions in front of the jury, but for now, Mr. Anderson.
Dr. Constantine, in your records, you had put down, you had hundreds at
1001
1001 3817. There we go, bottom of the page. You put, she denied a history of sexual abuse. Do you see that?
Yes.
She stated that one time previously a doctor had looked at her private parts but did not touch her, and it made her feel uncomfortable. You see that?
Yes.
And then she denied suicidal ideations. Upon receiving a note from this child in the context, and would you agree with me that the context you had set up was a history of sexual abuse? Would you agree that that was the first way to lead into the next question?
I asked the question of all my patients if they've experienced abuse.
Right. And immediately after that, a 10-year-old girl says, one time previously, a doctor looked at her private parts but did not touch her, and it made her feel uncomfortable. You see that?
Yes.
What is repression or suppression of sexual incident in children? What do they do if they have something bad happen to them sexually that they don't understand?
In some cases, when a child has experienced a sexual assault, they may not remember it at that time. In this case, what I saw here, when my discussions with Maya, where she said she had previously at another organization had a doctor look at her private parts, but it was part of a medical examination and that individual did not touch her.
Well, doctor, would you agree with me that a 10-year-old child, or perhaps even younger child, may not know exactly what constitutes sexual assault or sexual battery?
In this situation, a physician looking at the private parts of a patient would be part of a typical medical examination.
And are you aware of the prior proffer of Maya Kowalski in this case?
No.
All right. Well,
I
in a
don't
circumstance...
know.
Okay.
I don't know what you're speaking of.
Sure. Well, Maya Kowalski, your patient that you were describing here, if it was such that Maya Kowalski actually had a physician come in, a male physician, described specifically by height, weight, what the physician had on, a name tag, everything else, who came through the door and said, and walked up to her without a chaperone saying, "Can I take a peek?" And then went and pulled her drawstrings down below her vagina, pulled her panties down below her vagina, and stared at her vagina for a period of time long enough for the child to feel uncomfortable, and then turned around and left saying, "Thanks." Would that be the type of information that you would find necessary to report?
That was not what was reported to me.
I'm not asking you that, ma'am. I'm asking you if that set of facts came to your attention, would that be something you would have to report?
If there was a hypothetical situation where a patient presented to me a concern where any team member in our organization made them feel uncomfortable, outside of typical medical care, because sometimes medical care is uncomfortable, then I would talk to our risk management team, and if it met the statutes for potential abuse, neglect, abandonment per the Florida statutes for a report to DCF, I would make a report.
Well, you don't necessarily have to have risk management to do that. You are a licensed reporter. You would have to report no matter what risk management said. Isn't that true?
If it met the criteria for abuse, neglect, or abandonment.
In this, you say, Maya told you, she stated, one time previously, a doctor looked at her private parts. She did not say a doctor at another hospital, did she?
She said previously, which meant for me at a different organization.
She had been at Johns Hopkins now for over, what, 10 days? Right. Did you know of any other organizations or hospitals she had been at?
Yes.
All right. How did you distinguish then between all of the doctors that had come and gone in Maya's life from the time she came in on the 7th, or even previously visits at Johns Hopkins from non-Johns Hopkins doctors?
I utilized the word previously in my note because it meant at a previous organization.
And why would it matter where it was if the child's comment there let you know someone stared at her privates and made her feel uncomfortable?
It would be for comprehensiveness of my documentation.
Well, it wouldn't really matter, though, would it? It doesn't matter whether it's a Johns Hopkins doctor or if it's a doctor from down the street or anyone. That's still a reportable offense, is it not?
This is not a reportable offense.
But the point is, you didn't follow up to find out if it was, did you?
This is not a reportable offense. This was part of typical medical care. There was no abuse, neglect, or abandonment.
How could you possibly know what was going on in that child's mind based on just that statement?
I asked her the questions. She told me that she felt uncomfortable and that she was not touched.
And 10-year-olds don't even really know what sexual abuse is in many instances. True?
In many cases, 10-year-olds do know what that is and are openly reporting it.
Yes, but in many cases they do not.
In some cases, I cannot speak to this situation. I wrote down what she reported to me.
Particularly in an instance where a child is being held, let's say, at a hospital, and a lot of doctors come and go in there. That child may not know what's appropriate and what isn't appropriate. Correct?
Each situation would vary. She had been to a number of hospitals and organizations.
If this was not a reportable offense, tell us the specific date, time, and circumstances of this encounter between Maya and a doctor.
I do not know, previous to her hospitalization with us.
You're a licensed reporter, are you not?
Everyone in the state of Florida over the age of 18
You're
is a
a
mandated
pediatric-
reporter.
Sorry, excuse me.
Let me stop. Let me stop you. Can you relay to me your encounter with Maya Kowalski about this incident?
What I have written here is what I recall from that.
Well, did you follow up with questions about the incident, or it's just she made the statement and then you moved on?
Well, this would have been a summary of my discussion with her. So I would have asked, were you touched? Did that physician touch you? No.
So I'm trying to ask you to relay as best as you can remember your discussion with Maya Kowalski that generated this note.
Mm-hmm. So in my discussion with her, I would have asked about potential sexual abuse in the past. Back and forth in our conversation, she declined that that happened. She described a situation at a previous organization where a doctor had looked at her private parts during a medical exam and that she was not touched.
And the conclusion that was a previous organization, is that what Maya said, or is that a conclusion you drew?
I utilized the word previously, which would have been that she told me it happened at another organization.
Okay, so she didn't say it was another organization, she just said previously.
Not here.
Did she say not here?
I have previously, which means to me it meant not at Johns Hopkins All Children's.
You can continue, Mr. Anderson.
Isn't it true that previously that term could mean the day before, or it could have meant the month before?
I would have considered it all to be in the context of the current hospitalization.
I'm not asking you that, ma'am. I'm just asking you as a matter of the English language. The term previously could have been from the day before or a month before. True?
Previously means prior to that time.
And prior to that time, for the 10 days before, where had Maya been?
She was at the hospital.
And all the doctors that she saw would be at that hospital, right?
Yes. Well, not necessarily. They may have medical staff privileges, but they may not be employed by the hospital.
The vast majority of
The
them
majority.
would be Johns Hopkins doctors. And yet, with that knowledge, you still did not pursue with this child any further details, did you?
This description that she provided would be similar to what we call a Tanner staging. So a physician for a child between the ages of 8 to 10 would be looking at puberty, they would be looking at pubic hair development, breast bud formation. So my understanding was this was part of a typical medical examination in which a Tanner staging was being completed.
You were aware that Maya had not reached puberty at this point, were you not?
I'm not a medical doctor, I wouldn't be looking into that.
You didn't know as you talked to this young girl whether or not she'd reached puberty?
I hadn't asked her about menses.
And isn't it hospital policy? Is it in fact most hospital policies? Isn't it in fact most every doctor's hospital policy that when you go in to see a young female child, if you're a male, you have a nurse or other chaperone?
I can't speak to the policies of all those organizations.
Is that not the policy at Johns Hopkins?
It is not part of my standard practice, and I am not aware of the policy specifically because I do not do that.
You're female. I'm talking about male doctors.
Object to the lack of foundation.
Right? Male doctors going in to see a female, especially a young female patient, especially when there's going to be disrobing involved, have some female proctor or whatever you want to call it, nurse, observer. True?
I can't speak to that. That's not my practice.
Did you see in any of Maya's records a doctor write the term, what was it, Tanner?
Tanner stage?
Tanner stage?
I do not recall. I have not reviewed every single record.
Did you look?
No.
Isn't it true that it could have been just as easily another doctor at that hospital who had come in and disrobed exactly the way Maya Kowalski previously testified?
I utilized the word previously, which meant prior to the current hospitalization.
Based on your opinion of the term?
Based upon what I reported in my note here.
Does the defense wish to have any questions for purposes of proffer?
Yeah, sure. Dr. Katzenstein, we're talking about your use of the word previously. Not what it means generically. Is what you're telling this court, when you put down the word previously, you meant that specifically to signify that whatever was being described did not happen at All Children's?
Correct. It meant previous to the hospitalization.
And what was described to you, what you wrote that day, was based on your conversation with Maya that day?
Correct.
Nothing in your note is in quotations, is it?
There are no quotes in that note.
Doctor, can I have you step outside for a few minutes?
Sure.
The doctor's outside of our presence. We're here on the objection to the question having to do with did she report any abuse while at the hospital or something along those lines?
I think it was more broad than that, Your Honor. I'd have to have the court reporter read it back, but it was just, did anybody tell you anything?
Any complaints?
Any complaints about Maya?
Any prior mistreatment was the phrase.
Okay, whatever it was in follow-up to merely just establishing her interactions with Kathy Betty, the social worker, from her perspective, were fine, and she didn't hear any complaints regarding Maya's treatment. That's all it was meant to do. It's not meant to open this door wide open. And I don't think the jury got any impression about anything related to that. I apologize if this cracked the door on this. I had no idea that this was going to lead to this, but certainly in open court, it's important for the organization to hear from Dr. Katzenstein. I'm sure he was going to proffer her while she was here.
Your Honor, this jury, it takes extraordinary levels of notes. They are on to everything happening here. The jury has now been led by counsel's intentional questions to a conclusion that nothing involving any type of assault, any type of, what was the term again, mistreatment occurred at this hospital when there has been clear evidence in a proffer of something and other evidence in court, evidence of what Kathy Beatty had done. But the problem here is the question wasn't limited to Kathy Beatty. This was an open-ended question in which the witness, and if I'm given a moment, I believe I can find the actual Florida statute, criminal statute, about this behavior as sexual assault. this describes an act of sexual assault if it was even the slightest follow-up to it. And with all due respect to the doctor, the term previously does not give license to all of the conclusions that the witness brought to bear. As a licensed reporter, she was absolutely obligated under these circumstances to explore this and to see what would happen to this little girl, and she did not. Then, capitalizing, I guess, on this, the defense now has this witness testify that nothing of the sort happened, leaving the plaintiffs with the dilemma of how are we going to go and cross on an extremely important point without getting over into an area that so far has been excluded. This puts the plaintiff at a great, great disadvantage in this case, because now it makes it sound like there's an issue of fact here about whether or not Maya was telling the truth on any of it. And so we would move the court to reconsider the whole issue as to the sexual molestation of Maya Kowalski, at least insofar at this point of being able to ask the same questions of this witness before the jury that we ask improper, and the court asked improper. And I think that is the only fair way to resolve this. I see no way an instruction could clear this up for us. I just don't.
If you need a response, the jury knows nothing about this. I don't.
That's the point.
How could a generic question about did you, whatever it was, see any untoward conduct about Maya, anywhere close to suggesting to the jury about alleged sexual abuse, non-sexual abuse? It was a generic question about just her general observations. It was not meant to drill down and try to prove or disprove something they may bring in a collateral lawsuit. I mean, we're doing our best to toe the line. I didn't show the note. There was nothing intentional about this. There was no emphasis to this question. I just strongly disagree that somehow a question that at best was mildly inadvertent in attempting to capture this somehow poisoned this jury with the impression that Dr. Katzenstein raised her right hand and is attesting that she reviewed the hospital record from A to Z and never saw anything untoward.
Here's where I'm at. I think I asked 2 or 3 questions.
Yeah.
In that 2 or 3 questions, I was able to deduce that she wrote the word previous. She made an assumption that it was at a previous organization. She didn't ask any follow-ups. And she, being this doctor, didn't, and perhaps in her mind, she just assumed it was this, whatever, the 10 or whatever. But it didn't sound like she made any sort of follow-up question as it, did this occur here? She just made it a conclusion that it was previous. And I got that in 2 or 3 questions. I'm talking now. So, the question you asked was something along the lines of whether Maya had relayed any abuse to Dr. Katzenstein. And I don't think the word abuse, what was the word, Mr. Whitney?
Had she reported any concern of mistreatment was the term.
So, it seems that the answer no gives the impression to the jury that Maya did not relay any impressions of mistreatment, which probably isn't the correct case, isn't the correct answer. If the assumption is that, or if the assumption is Maya's disclosure was talking about something that was occurring at Johns Hopkins Children's Hospital, and what day did this occur? 10 days after admission?
It was the 12th, I believe. 17th? Sorry, I keep thinking.
So now I'm in a pickle because the defense did not want to get into this issue. I excluded this issue, and now you're asking a question that gives the witness the opportunity to give the impression that Maya didn't say anything.
May I call her back and proffer to clarify this? Because
I asked a couple of questions on that specific issue.
But her testimony is going to be that if Maya had told her that that happened at this hospital, she would have investigated it further. And the reason why she didn't do a further investigation because it was very clear to her, and and talking to Maya that what Maya was reporting was something happened in a previous organization. I apologize if that was
We have done the proffer at this point in time. What should I do at this point, folks?
well. If the question,
Judge,
It's Mr. Shapiro.
yeah, I truly believe in my heart there's no way this jury heard that question and thought that there was any implication. I was trying to narrow it to this witness. If it would, I don't want it to happen because it would seem to imply that there's something greater, but I guess the cure to this would be as if Your Honor would tell the jury to disregard the last question and answer, which would be very damaging to the defense.
Well, the jury knows nothing about the alleged sexual assault because I've kept that out.
Right. So,
At your request.
Right, I understand. I guess the cure would be to just tell the jury to disregard the last question about I'd have to talk with my defense team. That would seem highly prejudicial, but I guess that would be the cure, but I'd have to talk to them. Yeah, okay, then we would...
I'll take 5 minutes. We'll be back in 5 minutes, and hopefully you'll have an idea as to how you want to proceed.
Yeah. Let me tell you something. That 5 minutes is going to be the longest 5 minutes in that attorney's lifetime. He's probably had to change his underwear, I'm sure. And if you rewind it and look at all the other attorneys are sitting down, and some of them are like this and like this, like they don't know what to do. They have just lost their case. They have lost the case if this comes in. Oh my God. Even if it doesn't, now the jury has heard. Did she complain about any other mistreatment? No. Well, that's a lie. And they can't just leave it that way. The judge cannot leave it that way. So they're trying to figure out what to do. So he finally gives them a 5-minute break so he can talk to the rest of his defense lawyers, his bosses, his appellate attorney. He's probably brush up his resume. Anyway, he's fallen on his sword. He knows he screwed up. It's very, very unfortunate. In any case, they do come back finally. They bring the jury back. They bring the witness back, and their decision is, now the plaintiff could have asked for a mistrial and gotten it so easily. The judge would have said, granted, and then he would have had to start over from scratch, and he does not want to do that. They are so far into this trial, and it's so expensive. I cannot even begin to tell you the hundreds of thousands of dollars this costs to do this trial, to put these experts on. It is so expensive. Not just that, but plaintiff has at least 5 attorneys sitting there. 5 that are billing by the hour. And they're not just doing that like an 8.5-hour day at the courtroom. They get started early morning. They're there late at night. They're billing 14, 16 hours every day, every single one of those 5 lawyers. Same thing on the defense side, except the defense has 1, 2, 3, 4, 5, at least 5 lawyers too. 10 lawyers. 10 lawyers. Now, they're all charging different amounts. The main lawyers are probably charging $250, $350 an hour, I'm guessing. Now, the defense attorney, probably a little less. To $175, $200, I don't know. I'm dating myself. Back in the day when I was a lawyer. Then the other associates, they're probably billing a little bit less than that, maybe $125 an hour. I don't know. Times 14, 16 hours a day, every single day. That's what this costs to try this case. And the plaintiff doesn't want to start over. Now, he's doing it with money that the Kowalskis got when they settled the case against Sally Smith, the DCF doctor, and Kathy Beatty, the social worker. Now, they don't want to start over. So the mistrial is not declared. Finally, what they do is they bring in the jury in, and he tells the jury to disregard the last question. Now, I don't even know if the jury will remember the last question. They may not. It's a very sharp jury. But the other thing that was interesting is, and I wanted to hear at the end of her testimony what questions the jury was going to ask this witness. And he didn't let the jury ask questions. He let her go before they had a chance to ask questions. He just acted like he forgot. And I thought, oh, that's clever. Because I wanted to hear what questions the jury was, because they've been very insightful with their questions. It really gives you, it lends you some insight as to what they're thinking, and and no questions. They didn't get the opportunity to ask questions. Oh my God. Then the next person they put on the stand was a anesthesiologist. And I have not finished listening to him, but I want to tell you that, and I caught this, and I thought, wow, I hope the jury caught this. He worked for Johns Hopkins on and off since he's graduated as a anesthesiologist who specializes in pediatric pain management, including CRPS. And he talks about conversion disorder. He talks about CRPS, the whole thing. And he says, it doesn't matter what it is. These children are in pain, and the treatment is the same. And he says, and I don't know if they meant it for this to come out, and they certainly didn't dwell on it. He admitted that they now have a pain management program for CRPS at that hospital. Interesting, huh? Interesting. That he runs, this guy. So I don't think that's why they put him on the stand. I think they put him on the stand to talk about CRPS and what it is and how it's different from conversion and fictitious disorder and bunch of, but that came out, and I thought, wow, that is really, really interesting. All right, guys, that is the show for today. Don't forget to post your work in progress in the Crafting Journey Facebook group. If you're not in the group and you want to get in the group, it's just to answer a couple of questions, and I'll let you in. Yeah, it's just so I can keep the bots away from the group. That if you answer the questions, it lets me know you're a real person. Yep. And I don't care how you answer the questions. It doesn't matter to me. Anyway, have a great Tuesday. It's Tuesday and it's raining. I've been able to walk the dogs. It is gloomy, gloomy, gloomy outside. So I will be, I'm going to finish up this black that I've been putting down. I'll see you guys. And tomorrow's Crafting and Crime Show. Have a great day, everybody.